Welcome to The Explainer. In the fast-moving worlds of tech and finance, you've probably heard this loaded phrase getting thrown around all the time: regulation by enforcement. So what does it actually mean?
You'll hear this a lot from critics, and hey, even from officials inside the government. They use it to claim an agency is being totally unfair, that it's overstepping its bounds and pretty much making up the rules as it goes along.
But then you get the defenders, like SEC Chair Gary Gensler, who push back. And they push back hard. They argue, hey, this isn't some rogue operation. It's just enforcement. It's our job. So which one is it? A vital tool for regulators or a dangerous abuse of power? Well, to figure that out, we've got to get back to basics.
Okay, so to really get to the bottom of this, we have to start with the two basic jobs of any regulatory agency. Understanding this difference is really the key to the entire debate.
Think of it like this. On one side, you have an agency acting kind of like a legislature. That's rulemaking. It's a creative process, right? It looks to the future, it sets clear rules for everyone, and it usually involves asking the public for input. Then, on the other side, you have the agency acting more like a court. That's enforcement. It's reactive. It looks backward to punish one specific company for breaking a rule that already exists. The whole controversy really ignites when the line between those two jobs gets super blurry. It's when that second function, enforcing old rules, starts to look a whole lot like the first one, making brand new rules. This is what happens when a lawsuit against just one company suddenly creates a new standard for an entire industry.
There's a classic example from securities law that shows just how incredibly powerful this can be, and how a single lawsuit can wind up defining a whole industry for decades.
The most famous example of this is something called the Howey test. Now, this wasn't a law passed by Congress, and it wasn't a rule created after months of public debate. Nope, it came from a single Supreme Court case way back in 1946, and it was all about Florida orange groves. Seriously, the case was about whether selling shares in an orange farm counted as a security. Just think about how wild the reach of this one court case is. A legal test that was created for orange groves almost 80 years ago was later used to regulate chinchilla breeding, then life insurance contracts, and today, it's the main legal framework being applied to the entire world of cryptocurrencies. That is the incredible power of enforcement. One lawsuit setting the rules for generations.
So, if this whole process is so controversial and feels pretty unfair to the companies being targeted, why would an agency ever choose to do it this way? I mean, why not just write a clear rule for everybody from the start?
Well, the motivations really fall on a spectrum. At one end, you have good faith reasons. Maybe an agency is just trying to be cautious, filling in the gaps in the law one case at a time because the technology is new and the path forward isn't clear at all. Or maybe it's a crisis, and they have to act fast when the normal rulemaking process would take years. But then you get to the other end of the spectrum, and this is what critics argue, that agencies sometimes use this strategy to avoid public scrutiny, to sidestep having to do a tough cost-benefit analysis, or even to crack down on activities they just don't like but can't actually outlaw.
And this brings us right to the heart of the debate. It's really a high-stakes trade-off: speed versus fairness, innovation versus predictability. Supporters will tell you this approach is just plain effective. It lets regulators move at the speed of innovation. A single big-ticket lawsuit can send a powerful warning shot across an entire industry, and it tells the public, hey, someone's on the job. Plus, it makes the law flexible. It lets these old laws adapt to totally new challenges. Yeah, from orange groves to crypto, without needing Congress to step in every single time.
But the criticism is fierce. The number one charge is that it's just fundamentally unfair. How can you punish somebody for breaking a rule that wasn't even clear until you sued them? Critics also argue that the rules you get from this are just lower quality because they don't have that public input or deep research. This can make the agency look like it's just playing politics, which hurts public trust and creates a messy scattershot effect where some players get targeted and others are left alone.
Now, this is the crucial part. This isn't just some philosophical debate anymore. It has absolutely exploded into a high-stakes legal battle over the very power of government agencies themselves.
See, the aggressive use of this strategy, especially in really contentious areas like crypto and environmental policy, has triggered a massive legal backlash. The challenges we're seeing now aren't just questioning one lawsuit. They're attacking the fundamental authority of these agencies to regulate, period.
One of the key principles under threat is this thing called Chevron deference. For decades, this has basically meant that courts should trust the experts at an agency to interpret the law. It's been a huge pillar of regulatory power. But right now, the Supreme Court is actively reconsidering this entire idea, which could dramatically weaken these agencies.
And then there's the rise of the major questions doctrine.
This is the idea that for the really big stuff, we're talking issues of vast economic or political significance, like regulating a whole new industry, an agency can't just reinterpret some old law. No, it needs a clear, explicit green light directly from Congress. And this doctrine is being used as a weapon right now to challenge agencies that are using enforcement to move into new territory.
So it all boils down to this final, critical question that courts, lawmakers, and all of us are grappling with. Is this a nimble, necessary tool for a world that's changing at lightning speed, or is it a dangerous overreach of government power that just short-circuits the democratic process and the rule of law?
The answer that we end up with won't just affect one industry. It is going to redraw the entire balance of power between agencies, courts, and Congress for a generation. It's going to define the line between protecting consumers and unleashing innovation. The only real question is, where is that line going to be drawn? Thanks for joining this explainer.